In this video, we're going to discuss the farcical retrial of Lucy Letby with regard to child K, and we're going to particularly look at the tactics of prosecuting barrister Nick Johnson in court. The first thing to note about this case is that when it was originally tried in the initial trial, there was no verdict on child K. Frankly, how Lucy wasn't found not guilty on child K, considering the complete absence of evidence, I have no idea. But nevertheless, she wasn't convicted on this initially. So it was eventually announced that child K would be retried. Now, no one really knows the reason for this, and the prosecution maintains that it was some form of legitimate retrial. The police maintain this, the Crown Prosecution Service maintained this, and that they were trying to get answers for the child, for the parents of the child. Obviously, many people believe that what they were really trying to do was silence the growing dissent that was brewing at this time. Of course, now it's grown enormously, and many people believe that the tube extubation cases in Liverpool are another attempt to silence that dissent. Now, whether we're ever going to see those cases go to court, I don't know. In any kind of rational world, they wouldn't go to court because they're based on exactly the same nonsense as child K. But of course, they tried in a very different climate to silence people, and they were successful. And it was a dispiriting time when there was growing concern about the conviction, and yet it was very difficult to talk about it, and certainly there couldn't be any newspaper articles. A kind of beacon of light at this time was the New Yorker article by Rachel Aviv, is now an infamous article, but it's important to remember that this was banned in Britain for a very long time, and it wasn't readable at the time of the retrial, and it wasn't readable in the time leading up to the retrial. Now, of course, I managed to gain access to it and I read it. It's interesting that Professor Jim Thornton, who's currently part of the defence, is a subscriber to the New Yorker, and so read about the article in the print edition of the magazine, and that was when he first heard about problems with the Lucy Letby case. But we were effectively silenced for quite some time because of this retrial. So, considering that Lucy Letby was already facing 14 life sentences, you would hope that there was a good reason for the retrial. I'll also mention that in the immediate aftermath of the retrial, we saw articles from The Guardian firstly, and also the Daily Telegraph. Felicity Lawrence and Sarah Napton primarily involved, also Martin Evans, Sophie Barnes and Will Bolton for the Daily Telegraph. And I'm sure without the retrial, these articles would have come out sooner than they did, but we had to wait a little while because of the silencing of the press due to this case being heard again. So one of the strategies of Nick Johnson and the prosecution in general during the retrial of child K was to repeatedly go over the previous convictions of Lucy Letby. Now, I'm going to summarise that firstly in this video, although even this is not a full coverage of everything that was said. I know for a fact that Nick Johnson would repeat the names of all of the infants over and over again and say, you murdered this infant, then you murdered that infant, and so on and so forth, but with their real names. So we can't cover this fully. We don't have a full transcript of the retrial. So I'm just going to give you a flavour of what it was like in the court case. So you can see here, trial judge Mr. Justice James Goss has told the jury, sworn in on Tuesday afternoon, that they are aware Letby, who denies the charge, has previously been convicted of murdering several babies and attempting to murder others. So we'll return to the comments of Judge Goss once we've been over what the prosecution had to say in court. Prosecutor Nicholas Johnson, KC, is now delivering the opening. He explains there was a long trial which took place in which Letby was convicted on 7 counts of murdering babies and 7 counts of attempting to murder 6 other babies. Then he says, Mr. Johnson says the date of concern is February the 17th, 2016. He says by this stage Lucy Letby had murdered 5 babies and had attempted to murder 3 more. she had twice attempted to murder one of the latter. He says after this date, Letby murdered 2 of 3 triplets on the 23rd to 24th of June 2016 and had attempted to murder twins on the 9th of April 2016. Mr. Johnson says these are not the only Facebook searches Letby had made, as she had searched for parents of other babies who had nothing to do with the case. He says Letby undoubtedly murdered babies and then searched for their parents. 2 of the Facebook searches for parents of 2 different babies Letby murdered are listed a minute apart. Further Facebook searches are shown, including repeated searches for some parents of murdered babies. And then we continue. So this is at 3 p.m. and they're talking about Child K. And here Johnson says, the fact Lucy Letby was doing nothing and the alarm was not sounding was that Letby, the convicted murderer, had displaced a tube. So he obviously dropped the fact that she was a murderer into just random sentences whenever he felt like it. Here we see the court has shown Lucy Letby made Facebook searches for the parents of babies she has since been convicted of murdering and attempting to murder. And they talk about a Facebook search for Child K. Then there's an ITV interview with Dr. Jayaram. Dr. Jayaram says the interview was a long time after the event and after Letby was convicted of murders and several attempted murders. Then we continue. This is still Dr. Jayaram being interviewed. Dr. Jayaram says the cluster of events in June 2015 were noted. Letby was later convicted of the murders of babies that month. The death of a baby in August 2015 is mentioned, for which Letby was convicted of murder. Letby was also convicted of murder of a baby in October 2015 and twice attempting to murder a baby in September 2015. Then we now have Mr. Simon Driver joining in. So Mr. Simon Driver reads out an agreed fact in relation to Letby's murder and attempted murder convictions. Letby was convicted last year of the murders of 7 babies and attempted murders of 6 other infants at the Council Chester Hospital between June 2015 and June 2016. So I just mentioned as well that Mr. Simon Driver, as part of the lawyers, one of the lawyers that's representing the families from that have been affected by this issue, and this stated here in their submissions, the Thirlwell Inquiry, that the family submissions are provided with an annex to their written closing in order to reflect these submissions have been prepared without the input of Mr. Simon Driver. So it's sort of acknowledged that this could be a conflict of interest, that he was junior prosecuting counsel in the original trial and was involved with both appeals of the Court of Appeal and will be involved as a junior counsel for the Crown when this case is referred back to the Court of Appeal again. So they argue here that he hasn't been involved in the drafting of these documents. The submissions have been prepared without his input, and therefore it's not a conflict of interest. We have to accept that this is true. Whether or not it's a conflict of interest, I will leave others to decide. He's, as you can see here at the end of the document, he's one of the signatories along with Richard Baker, KC. But to return to the retrial of Child K, so we see here, Letby is asked to agree that she has searched off Facebook for the names of babies that she has been convicted of murdering and attempting to murder. Lucy agrees that this is the case and says, I am not guilty of what I have been found guilty of. Asked if it was an innocent coincidence that she had searched the names of babies and parents of babies that she had been convicted of murdering and attempting to murder, Lucy says yes. And then there's further discussion. And then Nick Johnson begins his closing speech by saying, pointing towards a terrible list of the babies Lucy was convicted of murdering and how old they were when they died. He has the names of the babies Lucy was convicted of attempting to murder, 13 separate children. This is the shocking and dreadful context of this case. That's obviously the very first thing he says in his closing speech. He says Lucy was cunning and devious and committed a campaign of murder and attempted murder while remaining undetected for all those months. He said jurors should take into account that devious behaviour when considering the case. And then there's some further discussion here, and he says that Lucy is a devious murderer again. And then he goes on to say Lucy was convicted of murdering 2 further babies in June 2016. And then I'll just make a few reference to killing. So Mr. Johnson says here that Letby's other Facebook searches for parents of babies she killed has significance. There's an exchange here where Nick Johnson says, "You are just that sort of person who kills babies," and Lucy says no, and then Nick Johnson says, "You have killed 7 babies and tried to kill 6 others, one on 2 separate occasions." "No, I haven't." And then Letby dislodged the tube a further 2 times over the following few hours in an attempt to cover her tracks, and suggests that the first dislodgement was accidental. These were the actions of a cold-blooded, calculated killer. It can now be revealed child serial killer Lucy Letby was compelled to hear part of the sentencing remarks she refused to listen to last year as they were read out ahead of her latest trial. So it continues. Mr. Johnson says Lucy did not want a written record of her being present in the 3rd extubation. Lucy says she disagrees. "You tried to kill Child K, didn't you?" "No." Lucy again denies she killed and attempted to kill other babies. So you can see from that it was fairly extraordinary the extent to which they just repeated the terms murderer and killing, repeated her previous convictions. Now I'm going to go over the comments of the Judge James Goss, in a little while, but I can't see, and I'm sure viewers will agree, how you can conceivably have a fair trial in which someone is just being called a murderer over and over again, and being that the jury are continually informed of the previous convictions of Lucy Letby. But that would be the case anyway, were it not for the fact that, of course, there's been an enormous amount of media coverage of this case. This is one of the obvious reasons that it was impossible for the retrial of Child K to be a fair trial, and one of the obvious reasons that it never should have happened. So there's a report here from the Time where the Press Association notes that Ben Myers KC argued there had been overwhelming and irremediable prejudice to Letby because of the extent and detail of coverage and comment across all forms of media in the aftermath of the verdicts from her first trial, including from witnesses set to give evidence at the retrial. In legal argument ahead of the retrial, Mr. Myers said there was also highly prejudicial and emotive public comment last August from senior police officers who investigated Lucy Letby, plus the Crown Prosecution Service, and that public statements from detectives about a probe into potential further crimes by the defendant were also prejudicial. Mr. Myers told Mr. Justice Goss that the comments all came at a point when a retrial was still under consideration. He said, "This is not a question about inaccurate reporting. The problem in this case is that because of the fact of the previous trial and we have those convictions, they provide a glue by which irrelevant, inadmissible and deeply prejudicial comment and reporting will attach to this trial. There has been an outpouring deeply hostile and deeply prejudicial at every level, at a political level. For a juror to attempt to expunge from his or her thoughts about what they have heard about this case or what they thought they have heard is an impossible task." So I just want to dwell finally on that. I mean, I think most of what I said there is undeniable, impossible really to contest in a rational way, and we're about to see it contested in a completely irrational way. But I just want to dwell on the final sentence. So Ben Myers is suggesting here that it's impossible for any juror to remove this from their thoughts, because everyone had heard about this. It was in the news. It was massively in the news. It was headline news everywhere. It was all over the television. And of course, because of the nature of the allegations, the headlines and stories were pretty sensational, and the condemnation was very, very strong. So naturally, it's very, very difficult to select a jury that can possibly be impartial in that climate. And this is what Ben Myers is quite rightly arguing here. Now, if Lucy Letby was a free woman and this was the only allegation against her, then perhaps it would be justified for the trial to go ahead. But given that she's already facing 14 life sentences, it's very difficult to justify this taking place, and it's certainly impossible to argue that the jury can sit there and not think about her previous convictions. But of course, just in case they'd forgotten about the previous convictions, as we know, all the way through the trial, Nick Johnson said she's a murderer, she's a murderer, she's a murderer, she murdered babies, she murdered babies, she murdered babies, over and over and over again. Even what I've covered in this video is nowhere near the extent of that. So, responding to Ben Myers, Nick Johnson KC says the following: We submit nothing that has been said about Lucy Letby by anyone comes close to eclipsing the truly dreadful catalogue of murders and attempted murders of which Lucy Letby is responsible. Everything which was reported in the aftermath of those verdicts was fair and accurate. If it was shocking, that was a natural consequence of the unprecedented dreadful offending of this defendant. The convictions themselves and the notoriety of the defendant are not susceptible to the fade factor, but the convictions are admissible in these proceedings. The material, the reporting that is complained about, is susceptible to the fade factor because it is utterly eclipsed by the dreadful offending. There used to be a saying in this part of the world, today's front page, tomorrow's fish and chip paper. It is the crimes themselves that will live long in the memory. It is not the relatively obscure detail of various commentators in various mediums that can possibly eclipse the crimes. Her crimes will always eclipse any comment made about them or about her by lawyers, police officers or journalists. Explaining his decision to refuse the application to stay the proceedings as an abusive process, Mr. Justice Goss said, "I am satisfied that any prejudice to the defendant from the publicity in the media is not such as to preclude the defendant from having a fair trial." So, in response to this, I will just make the following point. So, Nick Johnson argues that the media coverage doesn't matter, it's the crimes themselves. The crimes themselves will live long in the memory. Well, as absolutely no one was bore witness to those crimes. Indeed, literally no one has seen Lucy Letby do anything wrong to this day, and no one saw her do anything wrong with Child K. That's an agreed fact from both the defence and the prosecution, although Nick Johnson tried to introduce something into the closing speech that we know to be untrue. But literally no one has witnessed these crimes, but certainly the general public have not witnessed these crimes. The only reason that we know about the existence of these crimes is from the media reporting. So to try and divorce the two, to try and extricate the media reporting from the crimes is ridiculous. Obviously what people remember is the media reporting. They don't remember the crimes because they didn't witness the crimes. But it's okay because Justice Goss is satisfied that this is going to be a perfectly fair trial, just as he was satisfied that Dewi Evans should be allowed to give evidence in the first trial, despite the extraordinary intervention of Lord Justice Jackson. So then we see Judge James Goss continue here. The evidence of her convictions will be in evidence before the jury. It will be subject to the necessary directions to the jury as to the use to which they may and may not put this evidence. They will also receive a direction as to the importance of reaching their verdict on, and only on, the evidence placed before them and nothing else. So I would immediately say in response to that, Mr. Goss, that you allowed the prosecution to say over and over and over again that Lucy Letby was a murderer and Lucy Letby was a convicted murderer and that Lucy Letby had murdered babies, and to list all the names of the babies and say you murdered this baby, then you murdered this baby, then you murdered this baby, and that continued repeatedly all the way through the retrial, because I know someone who saw every second of the retrial. And I've heard a report from that person, and I know exactly what happened. And even this video can't cover the true extent to which that occurred. So if you're going to allow the prosecution to do that, how is it possible for the jury to reach a verdict on and only on the evidence placed before them and nothing else? You basically said to them, as we'll see in your directions, I'll just forget about what happened previously. Anyway, let's continue. Experience has shown that juries can be relied upon faithfully to follow such directions. Has it? What evidence is there for that exactly? So human beings can just put all of their prejudices out of their mind. In what world does this happen? But apparently, according to Judge James Goss, experience has told him this occurs, despite everything that's easily observable about human nature. The media coverage will, in any event, have been diluted by the fade factor since the verdicts in the original trial were reported. I mean, incredible. And this introduction of the fade factor that features heavily in the Court of Appeal verdict as well is sensational. The jury will forget that they're attending the trial of Lucy Letby, and they will forget during the trial of Lucy Letby what Lucy Letby has done previously and what was written in the media about Lucy Letby, even though they are continually reminded of this all of the way through the trial, and Judge Goss does absolutely nothing to prevent this. The fairness of the trial is not compromised, though, nor could the court's sense of justice and propriety be offended, or public confidence in the criminal justice system be undermined by the trial proceeding. Well, I think it can be diminished. Whether it's undermined entirely, the thing is, the public just go about their daily lives and they just do their jobs and they don't really think about whether or not the criminal justice system is sound. So I think if people really thought about this in any depth or even superficially, then naturally it would certainly diminish their confidence and faith in the criminal justice system, just as it has diminished mine. The fact is that people don't pay attention to court cases. So this is another comment that's made in the Court of Appeal verdict. Unfairness to the defendant is not required in relation to this limb. The focus is on whether a stay is appropriate in order to safeguard the integrity of the criminal justice system. The matters raised by the defence can be addressed and accommodated by the trial process, including any suggestion of malpractice or financial or other motives for untruthfulness on the part of any witness. The accounts witnesses are given of events at any time are all matters of record and available to be adduced and challenged in the trial process. The fairness of the trial is not compromised, nor could the court's sense of justice and propriety be offended or public confidence in the criminal justice system be undermined by the trial proceeding. So that is the full statement that is alluded to on the previous page. So what this seems to suggest to me is that the propriety of the court and the reputation of the court is more important than fairness to the defendant. Now, I'm sure that Judge Goss would say that's not what I intended. It's so difficult to interpret the words that these people use. Can you imagine reading an entire book of this? It's just deliberately designed to be as impenetrable as possible. But I would suggest, so they're talking at the start about unfairness to the defendant is not required in relation to this limb. The focus is on whether a stay is appropriate in order to safeguard the integrity of the criminal justice system. Now that certainly suggests to me that they're saying it's more important that this trial takes place in order to safeguard the integrity of the criminal justice system than any considerations related to the defendant. I'm willing to hear other people's interpretations. I know that legally qualified people watch these videos and often comment. So if you have an opinion on this appallingly, horrendously written paragraph and what is being stated, then I'll be interested to know. It seems to me that, not that surprisingly, they're placing the propriety of the criminal justice system, as it is described, on a pedestal, and a pedestal that is above the defendant. But that's just my interpretation of these words. I'd be interested to see what anyone else thinks. So, at the very beginning of the trial, we've alluded to some of this explanation previously. Judge James Goss said the following: "You decide the case on, and only on, all the evidence placed before you. There will be no more, and you must not speculate about..." I think it just trails off there. "As I said at the very beginning of the trial, you must not approach the case with any preconceived views." How is that possible? How can that even remotely be possible when everyone in the jury knows who Lucy Letby is? If they don't know who Lucy Letby is, they're told this is Lucy Letby as the defendant. They must. It would have been almost impossible for anyone in Britain not to know who Lucy Letby was. They're then at the trial of Lucy Letby. All the way through the court case, the prosecution is saying Lucy Letby's a murderer. Lucy Letby's a murderer. Lucy Letby's a murderer. How can they possibly approach this case without any preconceived views? How? It's completely unfeasible. And it's not surprising. The jury this took a couple of hours, she's guilty. How could they possibly come to any other conclusion? Most people just don't have the intellectual capacity. I'm not saying that I would myself. If I thought someone was a murderer and I was told repeatedly they were a murderer and then they were accused of murdering someone, I would like to believe that I myself am capable of just objectively looking at the evidence as I was required to do. I would like to believe that is the case. Most people are not capable of that, I can tell you now. But it's certainly, if you want this to be a fair trial, the way that it's been approached and the things that have occurred in the court are absolutely inimical to anything that would approach fairness. And so Judge James Goss continues, "And you must cast out of your decision-making process any response or approach to the case based on emotion or any feelings of sympathy or antipathy you may have." How? How the hell are they supposed to do that? if they believe that Lucy Letby has murdered 7 babies and attempted to murder 7 others, I don't think those are the precise. No, those should have been the correct figures because there's 14 life sentences. I don't know what. Oh no, because I think there's one baby where there's 2 charges. So there's 13 infants that were involved with 14 charges. So how the hell are the jury supposed to edit that out of the decision-making process under any circumstances, let alone when they're being told all the way through the retrial, Lucy Letby's a murderer, Lucy Letby's a murderer, Lucy Letby's a murderer. Well, I'm not going to step in as the judge, but hey, cast all that out of your decision-making process. So then Goss says, it is instinctive for anyone to react with horror to any allegation of deliberately harming a child, the more so a vulnerable, very premature baby. So what he's admitting there is that all of the attempts of the prosecution to make the original trial as emotional as possible and to put all this very emotive eyewitness testimony, none of them of course ever actually witnessed anything, in the court case would have the effect of causing anyone, as he puts it, to react with horror, which would then obviously prejudice the decision-making process. It's quite surreal what these judges will say in court, and it flies in the face of all reason or any kind of logic. You can just pick it apart logically so easily, and yet it just remains legally valid somehow. I just find it extraordinary, but I mean, he's just admitting there that as soon as you say someone, it's an allegation. He's not even saying if someone is proven. So as soon as you say this person has murdered a baby, this person is alleged to have murdered a baby, anyone will react with horror. So they're immediately becoming emotional. So that's immediately compromising their thinking process. And then it's not just as if it was mentioned once or twice in the original retrial, that there was a lot of very harrowing testimony. Liz Hull said that she cried. I can understand why. It must have been very upsetting, but that really shouldn't be part of the court case in my view, because there's no evidence. It has no evidential value. None of the eyewitnesses saw anything. We should stick to the facts. And in fact, the judge who presided over that case has just admitted that. Anyway, he continues. You will naturally feel sympathy for the parents of child K. So that's just further emphasising what he said already. You must, however, judge the case on all the evidence in the case in a fair, calm, objective and analytical way, applying your knowledge of human behaviour, how people act and react, and using your common sense and collective good judgment in your assessment of the evidence and the conclusions to be drawn from it. So it's fine to tell people that, but telling people that doesn't necessarily mean that they can actually do it. So it would be great if all people could assess things in a fair, calm, objective and analytical way. But unfortunately, that's not how human beings operate. I've mentioned previously this film, The Century of the Self, which is an exceptional documentary film. And it talks about how advertisers, over a period of time, realise more and more and more, thanks to this gentleman who's called Edward Bernays, who's sometimes described as the godfather of public relations. And he realised you don't sell things to people by trying to convince them rationally. What you do is appeal to their desires or appeal to them emotionally. And that's, of course, how we see products marketed today. It's all image over substance. It's all trying to connect with your emotions. It's all trying to convey a certain impression of what this product is like. I mean, a great example of that is McDonald's, who you'll watch McDonald's adverts, you won't even see any food. It's all about trying to engender a feeling around their product and their very recognisable brand. McDonald's, and indeed other advertisers, McDonald's are only one example, they're not even necessarily the worst example, but they do not say to consumers, right, we've made the best product, we're now going to explain to you objectively why this is the best product, and then you can make an objective decision about whether or not it is the best product, because it's known that doesn't work. And it's known whether consciously, subconsciously, whether from personal experience, whether it's just something that the prosecuting barristers have absorbed culturally. They knew that they needed to make it as emotional as possible, which is exactly what they did. So the judge just allowing the the prosecutor to do all this stuff that I've shown in the video and then just say, oh, but, make sure you judge the case rationally. Completely pointless. You do not have to resolve every conflict in the evidence and be sure about every point that has been raised or try to determine exactly what happened. Why should you have to try to determine what happened? You are not detectives, and you may think it would be a remarkable and exceptional case in which a jury could say, we know everything about what happened in any case. Possibly you could make the argument for some of the cases from the original trial. However, this is a relatively... it's not even correct to say relatively. This is an extremely straightforward case, which even the prosecution, as we're going to see, says that it all rests on one matter and one matter alone. So therefore, it should be absolutely not even critical. It should be sacrosanct to determine indeed exactly what happened. The jury should be able to sit there and think, we know what happened in this case, or we're convinced that we know what happened. Not, oh, we've got the vague idea that Lucy Letby might have done this, and we've got the vague idea that Lucy Letby might have attempted to murder Child K. You're just weakening it even further. It couldn't be watered down anymore. What does the prosecution actually have to do? They just sat there going, Lucy's a murderer, oh, something might have happened. Do you trust Dr. Jayaram or do you trust the murderer? All right, you trust Dr. Jayaram, great, well, that's another life sentence. It's an absolute joke. It's a complete and utter joke. Indeed, as Mr. Johnson says here, the case may come down to a single issue. Do you believe Dr. Jayaram saying what he saw? Do you believe he's telling you the truth about what he saw? And if you do you accept what we allege Lucy Letby was trying to do, bearing in mind what we have also proved? So obviously here he's just leaning on the fact that Lucy Letby's a murderer, as he's told people over and over again throughout the trial. But don't worry, because the judge has said, you can forget all of that, jury. I'm going to allow Johnson to say this. I'm going to allow Johnson to say Lucy's a murderer, but you're going to be able to forget that and just think about it rationally. Don't worry. Now, I could spend half an hour going over the whole of Jayaram's testimony and everything that occurred in the court case and in the retrial. Perhaps one day I will do that. There is a whole chapter on this Child K retrial in my book. I don't want to spend that amount of time in this video because people know that his testimony was extremely unreliable, because we know that he previously gave a completely different account of events to the one that he reported in court. So that in itself obviously significantly undermines his testimony, and it led to Sir David Davis urging Cheshire Police to investigate Rafi Jayaram for perjury, considering the unreliable nature of his testimony in the court case. Now, of course, we're never going to hear anything about that ever again, because Cheshire Police are engaging in this massive arse-covering exercise, having conducted this. I mean, I would describe it as completely incompetent. There are many other ways of describing it, but I mean, I think that's a fairly mild but still accurate way of describing what they did. So I've obviously made these 8 videos already on the police investigation. I'll be making more videos in the future, no doubt. So finally, with regard to Child K, let's go over what the expert panel of world-class neonatal practitioners had to say about Child K. So Child K was a 25-week, 692-gram female infant, so extremely small, 692 grams, very premature, born nearly 4 months before the child is supposed to come out of the womb. It was born by footling breech. Now, I'm not an expert on footling breech, but I have been assured by obstetricians that this is no picnic. This is nothing to be taken lightly, but we will probably at some point in the future we will discuss the background to Child K and the obstetrics with Dr. Martin Pittman. At birth, she was dusky, floppy, and had low heart rate, 60 beats per minute, and no spontaneous respiration. So not great, obviously. She's immediately floppy at birth with a very low heart rate and barely breathing. According to Dr. Evans, though, none of these infants required any oxygen support. She was resuscitated with bagging and intubated after 3 attempts with a size 2 endotracheal tube. blood-stained secretions were noted. So none of this sounds great, does it, really? So the fact there's blood-stained secretions, I accept that I'm not a neonatal expert, but that would suggest that they've made another intubation error with the endotracheal tube. She was mechanically ventilated and a large air leak of 94% was noted. Her blood gases showed respiratory and metabolic acidosis. 1.5 hours later, she desaturated. A consultant bagged her with neopuff, but there was no chest movement. The capnography test was negative for carbon dioxide. He re-intubated child K with a size 2.5 endotracheal tube, re-established chest movement, and stabilised the infant. Chest X-ray was consistent with respiratory distress syndrome or pneumonia. There were 2 further episodes of desaturation requiring resuscitation. Child K was transferred to Alder Hey Hospital. So the reason that this infant was transferred to Alder Hey Hospital was because the infant needed to be in a tertiary unit and should never have been in the Counter Chester in any capacity, let alone should this infant have been born in the Counter Chester. You can see that there's a litany of chronic health problems associated with this infant. This infant was really, really struggling. Child K required a size 2.5 endotracheal tube. So this is a record from the neonatal experts of essentially all the mistakes that have been made in relation to child K. Instead, she was traumatically intubated with a size 2 endotracheal tube with a resulting 94% air leak, which I'm sure you'd agree sounds pretty serious. As a result, ventilation was ineffective because 94% of the air was leaking out and only 6% was entering the lung. Effective gas exchange could not occur and mechanical ventilation could not generate sufficient pressure to keep the small air spaces in the lung open. This led to gradual collapse of the small air spaces in the lung and deteriorating gas exchange. When the tipping point was reached, the infant decompensated, desaturated, and collapsed. Bagging to reopen the collapsed small air spaces in the lung requires relatively high pressures. With a 94% air leak, bagging with the neopuff, which has a safety feature to limit air pressures, did not generate sufficient pressure to move the chest. Capnography did not work because the device measures buildup of carbon dioxide in the endotracheal tube during expiration. But with 94% air leak, the carbon dioxide could not build up sufficiently to trigger measurement. There is no evidence to support dislodgement of the endotracheal tube. The consultant stated that he did not hear the alarms, but a nurse, not Lucy Letby, stated that when I returned to the unit, I immediately became aware of the alarms sounding from child K's incubator. So there's another example, another eyewitness account from the time, which indicates that the testimony of Jayaram is unreliable. But you can see that there were terrible mistakes made on the unit, which led to problems with this infant. But we'll cover this in more depth shortly. Firstly, just go over the 5 conclusions of the panel. There is no evidence to support a dislodged endotracheal tube. The clinical deterioration was caused by use of an undersized endotracheal tube. The initial intubation was traumatic and poorly supervised. The consultant did not understand the basics of resuscitation, air leak, mechanical ventilation, and how equipment that was commonly used in the unit, e.g. neopuff and capnograph. There is evidence that the incubator alarms were not turned off. So that is the record of the expert panel with regard to child K, and you can see firstly, this child was born in an incredibly vulnerable state. This child needed to be managed extremely well. This child should have been in a tertiary unit, and then they made numerous mistakes. And even when the child was transferred back to a tertiary unit, sadly child K passed away, but that was not hugely surprising. To argue that Lucy Letby played, even if she had removed the endotracheal tube, for which there is no evidence, obviously, it would likely have been accidental anyway, but even if it had occurred deliberately, to say that that was significant in the collapse, deterioration, and then ultimate passing of this child 3 days later is pretty poorly founded, I would suggest. But of course, there is no evidence whatsoever that the endotracheal tube was even dislodged, let alone that it was done deliberately, which is frankly preposterous based on what was provided in court. An utterly ludicrous allegation that should never have been put in a courtroom. And let me finally remind you that Lucy Letby was going to be charged with murder for this infant. This infant, where the child should never have been born in the Council of Chester in the first place. The child should never have even been in the Council of Chester under any circumstances. The child should have been on a tertiary unit. That was acknowledged by the child being transferred to a tertiary unit. This is a child that was born incredibly vulnerable, incredibly small, incredibly premature, and then that had extreme breathing difficulties from the moment of birth. Undoubtedly, this child was at huge risk of collapse and sadly at huge risk of death, even if managed well. Then there were a catalogue of mistakes on the unit, and they were all mistakes related to breathing. As we've seen, the majority of air was leaking out, bleeding was caused. There's all kinds of very serious problems that we see repeated continually on this unit. And then not only is the infant transferred out of the hospital, so the infant dies 3 days after anyone with the Council of Chester, anyone from the Council of Chester has had any contact with the infant at all. Not only that, but also there's not even any evidence pointing to Lucy Letby having dislodged the endotracheal tube. That's why this is the number one point, that there's no evidence. The only evidence, and even the prosecution concedes this, is the testimony of Jayaram. So we've seen how reliable that is, because he's given two completely different versions of the same event. And yet the entire prosecution case is founded on that. And in order to try and overcome these problems, the prosecuting barrister just said repeatedly all the way through the trial, Lucy Letby is a murderer, and reminded the court of her previous convictions. And in response to that, Judge James Goss said, "Oh, don't worry, they can forget about that. I order you to forget about the fact that she's a murderer. Lucy Letby's a murderer. Just forget about that. Forget about that. You don't need to remember that. Just cast that out of your mind and just assess this case rationally on the evidence that's presented." It's just an absolute farce. The whole retrial was an utter farce. Again, it should never have gone to court. There's not even this. Even if people could possibly believe, I don't know how, but if the people could possibly believe that the original trial was legitimate, there's no conceivable way this should ever be in a courtroom. As a standalone case, for one nurse, there's just no prospect this would have gone to court, let alone that it would have secured a conviction. The fact that it secured a conviction is genuinely embarrassing for the criminal justice system. In summary, there is literally no evidence to support the conviction of Lucy Letby in relation to child K. The infant sadly died in another hospital 3 days after anyone from the Council of Chester had engaged in any contact with the baby. I'll just remind you, this didn't stop the prosecution from wanting to convict Lucy Letby for actual murder for this infant, even though she didn't have any contact with the infant in the last 3 days of the infant's life. And indeed, they went into the court case. It's only at the 11th hour that they changed this to attempted murder. It was going to be in the court case as murder, and they all had the pre-trial meeting thinking that it was going to be in the court case in that form. During the court case, the prosecution was allowed to continually call Lucy Letby a murderer. In fact, the prosecution was allowed to repeatedly list all of the previous indictment and all of the details. Judge Goss gave the jury what can reasonably be described as palpably ridiculous instructions. The retrial on child K was simply nowhere near a fair process. No one in their right mind could possibly believe otherwise. Although this is not proven, it seems very likely that Cheshire Police and the Crown Prosecution Service pushed for a retrial so that growing criticism of the original trial and their conduct could be silenced for 6 months. As is now infamously known, Dr. Ravi Jayaram gave an unreliable account in court, critical because even the prosecution concedes that this eyewitness account is the only item of evidence in the court case. Cheshire Police are supposed to be investigating Dr. Jayaram, but it can be guaranteed that we will never hear any more about this, as they're currently engaged in a massive arse-covering exercise, which has included abandoning their own Twitter account. Comments made by both the prosecution and the Court of Appeal with regard to the fade factor are asinine to the point of bordering on the surreal. So that's all I have to say at this point about the retrial of child K. It was truly ridiculous. It should never have been in a courtroom. There was no evidence presented. What evidence was presented should have been laughed out of court. It should never have been allowed to form the central allegation in a court case for murder. In my view, the only reason this case went back to court was to stop us from talking for a bit, and in that sense it was successful, and theoretically Lucy Letby is facing a life sentence over this infant, although given she was already facing 14, I'm not sure that particularly matters, which begs the question of why it went to court in the first place again. But I hope you found this informative. If you have any comments or questions, please do leave them in the comment section. I'll look forward to reading them.